For the time being, they are there. So this is something. And now giving the floor to one of the partners of the project, Barry Fitzpatrick of Cara-Friend Association. He is there.
Good afternoon, everybody. It's a great pleasure to be with you here in Rome. I'm just getting my slides up on the screen for you. So I'm not sure, this is quite a legalistic presentation. I'm looking at European EU social law and, to a lesser extent, policy to rainbow families at work, which is the very specific topic of today's seminar. So I will try and give a few examples as I go along and hopefully make some interesting points, but you may find your lunch more appetizing than the presentation, but I'll do my best to make it interesting for you. You can see my email address there. I'm sure that either the organizers or I can you send you these slides if you want to receive them, and you can certainly contact me or the organizers to receive these slides later. Okay, let me quickly move through the subject of my presentation. Obviously, everything in EU law now starts with the Treaty on the Functioning of the European Union. And the key article from the point of view of non-discrimination on grounds of sexual orientation is Article 19. And Article 19, unfortunately, even after all the revisions of the treaty, is one of the few articles left in the treaty which still requires unanimity in the Council of Ministers and merely the consultation with the European Parliament. So we'll see the Framework Employment Equality Directive 2000 is interesting. It was passed along with a Race and Ethnic Origin Directive, which I'll mention, before the accession of many new states into the EU, because both these directives were passed on the basis of unanimity. I see in the paper of our long-distance colleague, who we may yet hear from this afternoon, he complaining about the blockage in the system for the Framework Directive to cover goods and services and all these other issues. But under Article 19, these fresh proposals require unanimity across now 28 states. So maybe the laws that we already have on sexual orientation discrimination are likely to be as much as we're going to get in the foreseeable future. On the other hand, the treaty also incorporates into EU law the Charter and Fundamental Rights of the European Union. This effectively, Article 21 of that Charter, which is now increasingly being recognized by the Court of Justice of the European Union in interpreting all aspects of EU law. Article 21 has a non-discrimination clause, and sexual orientation is specifically mentioned within it. Also, from the point of view of this workshop, of course, the Charter includes economic and social rights as well as civil and political rights. In some countries, such as mine, we have an effective hierarchy where civil and political rights are enforced by the Court of Human Rights, and economic and social rights are enforced by the European Committee on Social Rights, which is certainly not taken as seriously in our courts, obviously, as the Court of Human Rights. So it'll be interesting as the Charter develops from a trade union point of view and a workplace labour market point of view to see the extent to which the Court of Justice will start interpreting these economic and social rights in the Charter. I'm going to concentrate on briefly on free movement and non-discrimination on grounds of EU nationality. I'm going to say something on non-discrimination on grounds of sex, and then I'm going to carry you through the Framework Employment Equality Directive 2000, which basically prohibits discrimination on grounds of sexual orientation in employment and training. So, in terms of free movement rights, Article 45 of the treaty prohibits discrimination on grounds of EU nationality in employment. And this treaty article is backed up very extensively by a regulation which appears to be from the year 2011, but is in fact a codification of a very well-known regulation, 1612 from 1968. So one of the earliest acts of the European institutions was to set down a code of non-discrimination against EU workers. So it's very much a market integration measure. It's not seen as a non-discrimination measure. It's part of the whole free movement edifice at the heart of the treaty. But regulations are directly enforceable in the national courts. Regulations at the EU level bypass national law and can be directly enforced in the courts. So basically the key article in the regulation is Article 7.1, and really what we're saying from the point of view of rainbow families is that so long as one of the partners is an EU national working in another member state, then that worker cannot be discriminated against by reason of his or her nationality in relation to any matters concerning the labour market. From the point of view of the children of rainbow families, Article 10 of the regulation is interesting because it provides that the children of a national of a member state who is or has been employed in the territory of another state shall be admitted to that state's general education, apprenticeship and vocational training courses under the same conditions as the nationals of that state if such children are residing in that territory. Now, what does children mean in this context? Well, a few were at the Toulouse seminar as part of this program when I looked at the 2004 directive in more detail, but you can see that it says this is the, again, consolidated directive on free movement across the EU. It says the direct descendants who are under the age of 21 or are dependents, and those of the spouse or partner as defined in point B. And then point B says the partner with whom the union citizen has contracted a registered partnership on the basis of the legislation of a member state if the legislation of the host member state treats registered partnerships as equivalent to marriage. So this is the patchwork of laws even across our EU. It's effectively if the children are the children of a registered partnership in one member state, they have moved to another member state where the civil partnership is recognized in that host state also. So we have heard much already about the trials and tribulations of moving around the EU, and that still applies to some extent. I want to briefly mention the sex equality legislation. Again, it's a 2006 directive on the implementation of equal opportunities and equal treatment for men and women in matters of employment and occupation. Of course, those who know the area of equality well, this is a recast directive going back to really merge and develop the 1975 Equal Pay Directive and the 1976 Equal Treatment Directive. In fact, by the time the race and framework directives were passed in 2000, incorporating many of the Court of Justice's rulings on sex equality, it was then discovered that the 1970s directives were actually below the standards of the 2000 directives, and so really sex equality legislation has been updated to ensure that it is at least, if not more progressive than that law on race and sexual orientation and other matters. So briefly to mention it, of course, directives, you may know, are directly enforceable in the national courts against public bodies and those bodies performing public functions. So even if a public function is contracted out to a private organisation, you can still enforce the directives against those bodies as if they were state bodies. If you're dealing with purely private bodies, then the courts are still under an obligation to do everything possible to reinterpret national law to conform to the terms of the directive. Now, basically, what is now the 2006 directive, the court made clear, I'm just giving you the recital to the directive here, but since the case of P and Cornwall City Council, the Court of Justice has recognised that those who have gone through gender reassignment, who have gone through transition, that to discriminate against them is sex-specific discrimination and therefore direct sex discrimination. So the 2006 directive applies to a range of trans people. Alexander in his presentation talked about these shades from black to white and issues of intersex people. The Court of Justice therefore remains to be seen what it makes of these various relationships, but it seems to me that many of them are obviously, the whole point of the P and Cornwall County Council case, well, you can't get anything more on grounds of sex than changing it. So there may well be much more case law in the Court of Justice on gender identity under the sex equality legislation rather than on issues of sexual orientation discrimination. You'll know that the Court of Justice refused to treat sex equal pay law on the basis of that to discriminate against a partner is effectively on grounds of sex. So these were cases of benefits that were given to spouses but not to same-sex partners. The Court of Justice in these cases, such as Grant and South West Trains, refused to equate sex equality law with sexual orientation discrimination law. Whether that, and I think that matter is now closed, we now have the Framework Directive which covers discrimination on grounds of sexual orientation, but it only covers employment and training. Now that's not the topic of today's workshop, but nonetheless the sex equality legislation has been extended to cover goods and services, and it seems to be interesting after a case which I'll mention again, you may know of, Coleman, was a case where a mother was discriminated against allegedly on grounds of her son's disability. And it seems to me very hard to say that if you're discriminating against someone because of the sex of their partner, that isn't some sort of sex discrimination. Now that the Framework Directive is in place, but outside the Framework Directive, we have the issue, of course, that you have equal treatment legislation in terms of goods and services, in terms of sex, and that argument may re-emerge then. In time, you can read that there are a couple of cases going. There have been cases already in the Court of Justice on IVF, parenthood, and there are a couple of cases going through the court at the moment on the rights of mothers who have a child through a surrogacy arrangement. One is an Irish case, and one is a UK reference. So we have conflicting Advocate General opinions, so we can maybe watch and see what the court makes of them. They both agree that it's not sex discrimination because a male surrogate parent would have been treated in the same way as a female surrogate parent, and therefore it wasn't sex discrimination. But a male Advocate General, of course totally irrelevant, how dare I suggest anything else, the male Advocate General thinks that the Pregnant Workers Directive doesn't apply to the mother who's going to take over the mothering of the child, whereas a female Advocate General in the UK reference thinks that the Pregnant Workers Directive does apply. let's move on now to the issue of sexual orientation discrimination, and we move finally to the Council Directive 2078, which establishes a general framework of equal treatment in employment and occupation. Now, this was really, just to jump quickly, what started this process was the Race and Ethnic Origin Directive, which has an earlier number. This was passed really in June 2000, and there was concern at the introduction of a right-wing government in Austria. There was concern at racist and xenophobic attacks in the former Eastern Länder of Germany and other East European countries. So despite the unanimity rule, albeit only amongst 15 member states, they all finally agreed on a comprehensive race directive which applies not only in employment but right across goods and services as well. So this is a thoroughly comprehensive piece of legislation. What we then find is that 6 months later, having extracted race from an earlier draft to get it through, we did get the framework Employment Equality Directive. It covers religion or belief, disability, age, or sexual orientation, but it only applies to employment and training. So this is why, for the purpose of this workshop, obviously this is a very important directive, but nonetheless it wasn't possible to get a directive across these four grounds applying outside the labour market as well as inside it. So the scope of the directive are this is really, if you've worked in this area, this is really applying EU sex equality law, which has been developed since the mid-1970s to race and now these four other grounds, including sexual orientation. So it applies to conditions for access to employment, access to all types and all levels of vocational guidance, vocational training, advanced vocational training, retraining, including practical work experience. So we can say it applies to employment and working conditions, including dismissals and pay. And pay we know very well from our sex equality litigation covers issues around occupational pensions, although not pure social security. And so we can see that not only is this directive preventing discrimination against the same-sex couples working in the workplace, it's also, as we'll see, going to provide some protection for the children and young people in rainbow families, maybe to the extent that they're in the workplace or involved in issues such as vocational training and guidance as well. And of course, although I'm sure it's not necessary here in Italy or wherever, but it also protects against discrimination in the organisation of workers or employers and all that entails. So I'm mentioning the Race Directive. Really, the Race Directive came 6 months before the Framework Directive, but the provisions, substantive provisions of both are very, very similar indeed. So these are principles that we know very well from almost first principles of our both EU equality law and our national equality law systems. Direct discrimination shall be taken to occur when one person is treated less favourably, another has or would be treated in a comparable situation on any of the grounds referred to in Article 1. So it is unlawful, and each of the 28 states must transpose into their national law, but you can still use EU law directly in the national courts and in collective bargaining negotiations to ensure there isn't direct discrimination on grounds of sexual orientation. Ned made the point that many of the issues are about perceived sexual orientation, and it's very clear that this terminology on any of the grounds, on the ground of sexual orientation, includes perceived sexual orientation. It doesn't matter whether you are gay or lesbian, or bisexual. If you're perceived to be, then discrimination on that ground is prohibited. And mentioning Coleman again, clearly, this is like turning Coleman on its head, but if the children and young people in rainbow families are being discriminated against in the workplace because of the sexual orientation of their parents, that is still what has now become phrased associative discrimination. In other words, you can be prohibited to discriminate against a person because of whom they associate with. And Coleman was a case about a parent-child relationship, and we're saying, therefore, that obviously children in rainbow families are protected in relation to the sexual orientation or even perceived sexual orientation of their parents. Indirect discrimination is a very well-established principle where something is apparently neutral, but in reality places people of gay and lesbian people at a particular disadvantage compared with other persons. We have a case just heard recently in the Supreme Court in London, which you may possibly have read about. It's actually a goods and services case. It's about where gay couples were prevented access to bed and breakfast accommodation in two separate cases, and because the Christian owners of the bed and breakfasts would only allow access to double rooms to married couples, and we now have our Supreme Court actually two Court of Appeal decisions in two separate cases. One said this is direct discrimination because if you're restricting a bedroom to a married couple, then this is direct discrimination on grounds of sexual orientation. And the second Court of Appeal came in and said, well, we're bound by that other decision, but it's totally wrong. This is something which is apparently neutral, but places gay and lesbian couples at a particular disadvantage. So we had a principle of direct discrimination in UK law from the mid-60s and indirect discrimination from the mid-70s. And now, 40 years later, our Supreme Court is still trying to tell us what's direct discrimination and what's indirect discrimination. But these are well-established principles in terms of sex equality. Obviously, indirect discrimination is subject to objective justification, but it's quite whereas direct discrimination is subject to very few exceptions whatsoever. The standard provision on objective justification for indirect discrimination is, does the body have a legitimate aim? And you can't just make it up as you go along. If you want a legitimate aim for indirect discrimination, then you'd better have a paper trail indicating what was the reasoning, what was the aim behind the policy, in case you have an indirect discrimination. And then you have to ask the question, even if you have a legitimate aim, are the means of achieving it appropriate and necessary? Now, that actually in UK law will be applied to those bed and breakfast cases, and it is accepted in the courts that you could, as a Christian, have a legitimate aim in trying to restrict. The court judges have been a bit divided on that. Is it a legitimate aim for, and it could be a Christian employer, to have, issues around how they provide employment or provide services? But then you have to ask the question, is it appropriate or necessary? So it's suspecting, really, looking at European Court of Human Rights decisions on justification in the recent religious belief cases that you may have read about, that the Strasbourg Court applies a strict scrutiny approach to discrimination on grounds of sexual orientation. I think because of those cases like Grant and Southwest Trains, some people, lawyers on sexual orientation discrimination, are a bit more wary of the Court of Justice. The Court of Justice is not primarily a human rights court, but it's increasingly having to take human rights stances. And the very recent asylum decision, which only came out I think earlier this week or last week, shows that the Court of Justice is perfectly capable of taking a very strong line on sexual orientation discrimination as well. And so we come to the third, something maybe ways, maybe the most important of the legal concepts, both for the parents and raise both families and their children, which is the harassment provision. It's one thing to keep people out of the workplace. It's another thing to then to create an environment which makes them feel in some way excluded. So harassment, as we well know from our sex equality law already, involves unwanted conduct and related to any of the grounds, including sexual orientation, takes place with the purpose or effect of violating the dignity of a person, of creating, intimidating, hostile, degrading, humiliating or offensive environment. So obviously there may be very many situations in the workplace where a parent in a rainbow family may suffer that sort of environment, and given this related to any of the grounds, any of the children and young people in the workplace who suffer this sort of environment because of the sexual orientation of their parents are going to be offered some protection by that as well. The Article 2.5, unusually in the Framework Directive, does allow for public policy and public order exceptions, which we have heard mentioned today already. But now that sexual orientation discrimination is recognised in the Charter of Fundamental Rights, it's difficult to think anything other than that the Court of Justice will take a very narrow view of those public policy exceptions, and the sort of arguments that might be put in some context will be simply unacceptable. And so a final run in, really, these are typical provisions that we find in all the equality directives. There is obviously individual redress to the judicial process. Also importantly, from a trade union point of view and an NGO point of view, the directives apply that associations, organisations and other legal entities can bring cases in their own name on behalf of named individuals. There's victimisation provisions which cover being penalised for making a complaint under the directive. Article 13 promotes social dialogue over the content of the directive, including sexual orientation discrimination. Article 16 requires the correction of discriminatory provisions in contracts or collective agreements. And so this is an opportunity for the collective bargainers, if they come across direct or indirect discrimination against rainbow families and their members, to actually use those arguments to say that they must be negotiated away. So these are the sort of measures that have been in equality directives since the mid-1970s, but they're replicated again in both the race and the Framework Directive. So I hope you're satisfied to some extent about what's the provisions in EU equality law for rainbow families, and that you will now be able to enjoy your lunch as well. Thank you.
Thank you for the detailed presentation.